For today's case, we review a situation in which a state judge apparently interfered with immigration officials to the point that the state judge might be in violation of federal criminal law. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. For today's story, we are discussing United States of America versus Shelley Joseph and Wesley McGregor. This stems from an incident in which immigration was trying to arrest someone that was in a state courtroom. And of course, the state had authority over that person at the time, so they told immigration to wait while they were processing them. But then the state judge basically facilitated them being snuck out the back door and also lied to immigration officials in the process of doing so. So the United States attorney is bringing criminal charges against the people for their interference with the immigration enforcement. So the question is this a valid thing or not? So let's get to start with this. On April the 2nd of 2018, Judge Joseph presided over the arraignment of an undocumented immigrant referred to the parties by A.S. A.S. had been fingerprinted upon his arrest by the police in Massachusetts. After a check of national law enforcement databases indicated that he had previously been deported from the country and was prohibited from re-entering the country, which would make this a felony, being a second or more violation of immigration law. So the federal ICE issued an immigration detainer and warrant of removal for A.S. ICE sent these documents to the police, requesting that state officials notify ICE before releasing A.S. and, if necessary, detain him for up to 48 hours to allow ICE to take custody of him. These documents were provided to the Newton County Clerk Court Office, Probation, the Assistant District Attorney, and Defense Counsel. Now, as we've discussed many times, we have a federalist system in our country, which means, among other things, that state-level governments cannot be compelled or coerced into assisting federal law enforcement authorities. They can't be commandeered by federal law enforcement authorities. So, to the extent that the federal government is asking for the state's help, the state doesn't necessarily have to give that help. So, the state, taking notice of this and ignoring that would be one thing. Is that where it stops? On April the 2nd, a plainclothes ICE officer entered the Newton District Court to take A.S. into federal custody should he be released from state custody. The ICE officer originally sat in Judge Joseph's courthouse, but Judge Joseph later directed the clerk to tell the officer to leave, which at this point is a perfectly proper procedure, right? He's currently under the authority of the court. And so, you can direct, this alone would not interference make, right? So that would be fine. The government alleges that this directive violates state policy governing the treatment of ICE officials in the Massachusetts State House, which it might violate state policy, but that would not necessarily be a violation of federal law. The clerk did as instructed and also told the ICE officer that if released, A.S. would exit the courtroom into the courthouse lobby. Ultimately, however, this is not what transpired, and here's where things get legally problematic for the state-level officials. A.S. was released from state custody, but he exited the courthouse without passing through the lobby where the ICE official awaited. The government alleges, and this is the U.S. government, that Judge Joseph purposefully helped A.S. evade ICE by concocting a ruse under which A.S. would go downstairs to lock up, ostensibly to retrieve some property, and speak with his counsel via an interpreter, then exit the courthouse through a rear sally port exit. According to the government, Judge Joseph directed the clerk to go off the record while she devised this plan with the attorneys. At this point, the court-room recorder was turned off for nearly a minute, allegedly in violation of Massachusetts court rules. After the recorder was turned back on and the alleged plan was set in motion, the deputy used his access card to swipe A.S. out of the back door of the courthouse. All right, so this is where we run into problems, my friends, right? This is where we run into problems, right? The person is currently within the custody of the court while the proceedings are ongoing, right? So the police have to wait, whether state level police or federal level police, they have to wait in the gallery. They can't interrupt the proceedings, right? They have to wait until the court's done with them. And then once the court's done with them, then they can arrest them, but they're in the possession of the court. And the court also is in control of its courtroom. So they can say, okay, you got to wait outside the courtroom. All right, that seems proper. They say to him, when he's released, he'll come through the lobby. Great, fine. But then we enact a plan whereby we're purposefully, for the purpose of evading ICE, going to direct him outside the back. Now we're no longer failing to cooperate with law enforcement. We're actively trying to evade them and interfere with them. Uh-oh. Problems emerge rapidly. Let's read on. Judge Joseph argues the doctrine of judicial immunity shields her from criminal prosecution for actions taken in her judicial capacity. Both Judge Joseph and the deputy also argue the prosecution is barred by principles of federalism and due process, and by the 10th Amendment precedent holding the federal government may not commandeer state officials to execute federal policies. This is true as far as it goes. But that wasn't as far as it went. It went further. Finally, both defendants argue the government has not alleged facts sufficient to support the charges. The district court rejects the motion to dismiss. So now we go to the Court of Appeals. Judge Joseph's primary argument for challenging the indictment rests on the claim that, as a state district court judge, she is immune from federal prosecution for conduct alleged in the indictment. This immunity, she argues, protects her against not just conviction, but also against prosecution. Thus, she reasons she will lose an important part of the protection of her immunity if she is not vindicated until after trial. The flaw with this argument is that judicial immunity, even asserting that it applies in this criminal context, does not provide a right not to be tried that can serve as a basis for an appeal. In adopting this rule for our interlocutory appeals, that is, appeals while the case is still ongoing, the court recognized that absent such a strict construction, very many legal defenses might be said to confer a right not to be tried. So one of the things that the court is saying is, well, we are construing this right not to be tried very narrowly. In order for that to apply, you have to show some explicit statutory or explicit constitutional grounds, such as double jeopardy. Right? In that case, we'll hear your right not to be tried. But if you're arguing it for other reasons, right, then we're not going to hear that, because arguably many rules could be viewed as a right not to be tried. But that would completely circumvent what trial courts are for, which is to adjudicate many of these issues. So if it's not explicitly rooted in the Constitution or explicitly rooted in statute, we're not going to hear that before the case is over. By limiting these interlocutory appeals to those rights not to be tried that are explicitly set forth in a statute or constitution, the court avoids construing an exception in a manner that would swallow the rule, which is what would happen if we heard the whole thing every time. In this regard, the requirement the defense rests on an explicit statutory or constitutional grant of immunity from trial aligns with the Supreme Court practice of interpreting the collateral order exception with strictness in criminal cases. And this would be a collateral order because, again, it's not part of the standard appellate process. Judge Joseph also invokes the Supreme Court's holding in a case called Mitchell that denial of the substantive claim of absolute immunity is an order appealable before final judgment. But Mitchell was a civil case where more stringent rules apply to criminal proceedings that do not apply. Our prior case, decided 4 years after Mitchell, governs criminal cases. So Judge Joseph cannot obtain interlocutory review of the judicial immunity defense until they can show that the right not to be tried is explicitly grounded in statute or the Constitution. Because she conceitedly can point to no such grounds and relies instead solely on common law, this necessarily fails to meet our standards. So yes, she may have an absolute immunity claim, although it's not necessarily clear. Because to be absolutely immune, she would have to be acting within her judicial role. And this is arguably outside that judicial role, right? A conspiracy to ferret someone outside the door is not like rendering a decision. So absolute immunity isn't apparent. Even if absolute immunity is a thing, which is not clear, the Court of Appeals says, okay, as to criminal cases, we are not going to review that now, right? Because it's not clearly rooted in something, especially on the federal level. So, we're not going to review that now. We may consider it, after a conviction, but not now. Okay, let's read on. Defendants claim that the prosecution is a tool of impermissible commandeering, an attempt to require state officers to help enforce federal immigration law. No. As an initial matter, this argument seems to undercut defendants' claim that a court can adjudicate their defenses without considering facts contrary to those alleged in the incident. The indictment does not allege that Judge Joseph and the deputy merely declined to enforce immigration law. Right, we went beyond that. Instead, it alleges they affirmatively interfered with federal officials' attempt to enforce the law. That would be the difference. So we are not convinced the defendant's 10th Amendment theory is completely separate from the merits of the charges against them. Right. So yes, you take your pick of cases on this principle, right? There's a number of cases. Prince v. United States might be the most obvious case on this point, that you can't commandeer state level doctrines. Or I think it was Murphy versus NCAA dealing with betting issues in New Jersey. But either way, yeah, you can't force state officials to do your bidding, federal government, but they can't interfere. So like if they had just ignored all your orders and stuff like that, that would be one thing. But you allegedly did more by sneaking them out the back and actively lying to the feds about the whole thing. So that is not commandeering. That's just a conspiracy to violate the federal law under the worst possible reading. So, yeah. Nor does the defendant's 10th Amendment defense implicate some other right that would be lost by proceeding to trial, at least in this context. At base, defendants argued that they had the right to do whatever they did because federal immigration officials could not have required them to help enforce the law. That much is true. But this defense can be asserted at trial with any loss reviewable on appeal, which is also true. We turn our attention next to the defendant's claim that the indictment contravenes principles of federalism and due process because it rests on unconstitutionally broad readings of obstruction of justice statutes. I am doubtful. Citing no authority on this point, the defendants contend the prosecution implicates constitutional interests that cannot be adequately protected if this case goes to trial. I am very, very doubtful that this is true. The dividing line, to my mind, is not really that hard, right? At least in principle, and not even in application in this case. The dividing line is between not helping and interfering. The dividing line is between state officials not helping and not helping and hurting and interfering. So did they have to honor the request to hold? No. Like ICE says, hold them for 48 hours. Say, screw you, ICE. We're not going to hold them. We're not helping. Let us know if they're going to be released from custody. No, we're not doing any of that either, right? We're not going to help you. We're not going to respond to all these requests. Now, that's one thing. When ICE shows up at the courthouse and they show up in the courtroom, right? And they're like, yeah, but you have to wait outside. And then you sneak them out the back door. That's not merely refusing to help. That's interfering with the officer. That's obstruction. So I don't think the dividing line is too hard in theory or even in practice in this case. And with respect to defendants' due process claims, we have concluded in this civil context that if a party's due process rights were violated, there is no reason to assume that they cannot be fully vindicated on final appeal. The defense have failed to convince us this result ought to differ in their criminal case, where collateral order exception is even more limited. Given the structure of a collateral order doctrine, because remember, again, we're still on an interlocutory appeal. We're not on direct appeal, right? So this is all collateral, which is also disfavored in criminal law context. We find ourselves without jurisdiction to review the judgment, order denying the defense motion to dismiss. We therefore dismiss their appeal without expressing any views on the merit of this prosecution. Thus, that brings us to the end of the case, at least for the moment, of United States of America versus Shelley Joseph and Wesley McGregor. In this case, the United States government alleges that a judge and a deputy conspired with each other in order to actively thwart and obstruct justice of federal ICE officials. The judge and the deputy say, we're not compelled to help. And they're right. They're not compelled to help. If that was what was being alleged, I'd agree with them 100%. They don't have to honor that ICE detention order. They don't have to particularly notify ICE when they're going to release them. They don't have to do any of those things. That would be fine. But they can't interfere. And here they interfered. And here they engaged in a conspiracy to get him out the back door and lied to the government saying, oh, if when we release him, he's going to come out the front door. So, lying to a federal official, conspiracy, obstruction. Yeah, we are well beyond, in my humble opinion, merely not facilitating. We are into interference land. So yeah, the criminal trial will continue. And assuming that they are found guilty, which seems plausible, then I don't really see any of these appeals working when the case is reviewed. But at least for the moment, that brings us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.